Hello, it's Philip Taylor speaking from Richmond, Green Chambers in London. Now today I'm looking at a book which has come to us from Intersentia. We've reviewed it before. I find it's an important book because I deal with family law. It's International Survey of Family Law since, in fact, in 2019. Intersentia have taken on the publication. This particular edition has been edited by Margaret Brinig, and Elizabeth actually did the key review, and I had a good look at it and we had a discussion about it, but I thought it'd be interesting to see from her point of view how she felt this particular survey came out, and she's made some quite astute observations which I thought were really interesting when we discussed it. So the title for the review is Key Developments in Family Law Worldwide, Still an Area of Controversy, and of course there are quite a large number of areas of controversy which will continue in this decade 2020 onwards. Let's have a look at the book first of all. Paperback, standard form again, very much the Intersentia house style. There we go, you can see the back of the book there. I'll open it up. It's not a long book, it's running to 350 odd pages. The index of the back page numbering, slightly shorter index than you might think. There's a lot of footnoting, as you can see from the back. As I say, runs to 350 odd pages. There's the front of the book there, and it mentions that it's actually published on behalf of the International Society of Family Law, which I think is again very helpful because you've got the international aspect. Intersentia, of course, well known to you from Cambridge, Antwerp and Chicago. There's the information there about the book, and you can see all the basic information is given there. Then there is a preface from Ms. Brinig from South Bend, Indiana, dated September 2019, and so she's actually brought things together very nicely in the time, because obviously the time we're talking about is 2019 itself. Then you've got the usual structure. As I say, we've reviewed the work before. You can see it's done by country, starting with Albania, running all the way through the various countries, and the various issues in those countries. So for instance, we've got Italy there, then we're running through to Korea, you've got a whole range, Serbia, the Seychelles, and then right at the end you've got the UN Committee on the Rights of the Child and the United States of America, dealing same-sex and different-sex relationships. For instance, you've got New Zealand, you've got a whole range of different countries, England and Wales, of course, because we are looking specifically at jurisdictions, are covered. Then you've got the list of contributors, large number of people involved in this, some of whom will be well known to you, some not so well known. But again, it does, because it's international in content, it's got a very international and diverse series of contributors. So you've got rather a nice chapter structure. You've got the short index, and then you've got the basic, the introduction. They call it resume, but it's an introduction. Then you, as I say, you've got footnoting. Then it runs through along those lines, and you can see how it is. There is paragraph numbering as well, so you should be able to find things quite easily, and of course you do get a conclusion. So you should find, depending on what you're looking for, when you look at the contents section, you should find what your main area of interest may be, because it just depends in family law on the sort of case you get, because I get a wide range of cases, and sometimes I'm not quite, obviously I need to have a little look to get some idea of what the views might be about certain things, because frankly, like much of what I do, having visited many countries around the world, I found that at the end of the day, I may use different terms, but the same issues, generally speaking, at certain times and certain parts of the century, tend to come to the fore. Obviously, I'm speaking now from 50 years experience of working, and certainly in that period of time, having seen all the different jurisdictions, it's really rather interesting to see what actually comes out and what emerges from some of the countries, because the usual suspects will be there and the usual countries will be there with their particular views. So what do we say? Those wanting to familiarise themselves with the latest developments in family law around the globe should read this book, we think. Surveying 20 countries from Albania and Australia to the US and of course England and Wales, this volume certainly drives home the fearsome complexity of family law as it is interpreted and applied within a variety of jurisdictions. And as I've said, I think that's important because we are much more of a global community today than we were. And even in this country, you're going to have a large number of people who come from different jurisdictions. Now, conflicts and controversies in all too many jurisdictions emerge in the form of clashes between internationally accepted standards of human rights on the one hand and traditional and unacceptable cultural attitudes on the other. That's always has been the case, and certainly my experience in terms of family law disputes, it very much does come to the fore without saying too much about it, because we have our own views. But the key certainly to what I do is to remind people that they are asking for an adjudication in the England and Wales jurisdiction, so that's what we apply. So the cultural norms are going to be different. Looking at it from a jurisprudential point of view, the cultural norms are bound to be different, and it becomes evident that certain attitudes in particular are apt to give rise to certain cultural practices, which you will notice, of course, impact mainly on women and children, as well, of course, as vulnerable minorities. But I'm afraid it's the women and the children who take the majority of it. Now, the book has been published by Intersentia, and we have a branch here in Cambridge, and it's by no means a treatise on gender equality. That ostensibly is not its purpose. What it does do over its more than 20 chapters, authored by some 29 expert contributors, is to reveal entrenched injustices and culturally influenced resistance to certain concepts of fundamental rights. Without going into a lot of detail, we all know what we're talking about. And frankly, it's a very difficult problem because it does depend on the attitudes of people in particular countries. And as we say, in example after example, however, it becomes obvious that human rights violations against women will almost invariably impact on their children. And of course, the role and the status of women varies very much in some countries from one country to another. Whatever they say, it's different. Some countries, not naming them, treat women as second-class citizens. No question about it. And you have this appalling problem, even now, with an imbalance when it comes to wages between men and women and what they're paid. The same problems are there, and it's not going away. The thing is, it's public legal education to a certain extent, what I deal with on a very large number of reviews that I do, but it's trying to educate people about where we are, because there are encouraging signs of progress, though, in a number of areas, ranging from divorce and child abduction to changing definitions of parenting to surrogacy and, of course, much more. And many of these developments do indicate a kind of upward trajectory of progress and attitudinal change, we would hope. I certainly think that there is that happening. The common thread of opinion, of course, is that in most of the jurisdictions under scrutiny, it centres on the welfare of the child and what is best for the child. Obviously, we have the Children Act, the paramount interests of the child and so forth, which is, of course, the test. Now, in Canada, for example, it matters relating to the habitual residence of abducted children. It's stipulated that the view of a child of sufficient maturity should be given due weight if, for instance, the child objects to residing in a particular country or with a particular parent. And the UN Convention on the Rights of the Child provides that the child shall be heard in any judicial and administrative proceeding affecting the child either directly or through a representative and appropriate body in a manner consistent with the procedural rules of national law. I'm glad that's in, because the time was there when I was dealing with family matters where they really were not considering, in my view, anything like the way they should today, the wishes and feelings of children. And so it's really good to see that this The UN Convention's there, and this is getting more exposure even now. Interestingly, we're reminded that this convention goes back 30 years. Well, of course, I've been practicing for 30 years, and I'm saying to you, in that period of time, we have been seeing a lot of changes. The book's penultimate chapter points out that while this convention has been ratified by 196 state parties, many of the said state parties continue to resist implementing it for a number of reasons. Unfortunately, they use cultural factors such as the prevalence of patriarchy and gender inequality. Implementation, concludes the argument, is the most critical element in the global effort to create a world fit for all children, and is still a problem in many countries. Topical, terse and timely, we think this survey is an absorbing and authoritative international survey for 2019, which should be considered essential reading for all family lawyers. And the date of the publication is given as at the 16th of September 2019. One quick look again. I'm probably repeating myself a bit, but repetition sometimes does help. Margaret's come up with a very good, brought a lot of people together, come up with an excellent survey this year. There's the front, there's the side, and then there's the back. You probably can't see too much of the inverse there from a distance. But opening the book in the middle, I'm looking here, Ireland. The path to reform. Very interesting, because you've got a lot of footnoting here. Talking about 1992, and it's looking actually at Ireland and the very substantial changes that have been taking place. This is a chapter on best interests as a limited constitutional imperative. You see, they're dealing with very serious issues. Now, the people in Ireland will have a vote, again, before too long. There has been what I can only describe as a seismic change there over a relatively short period of time. We, of course, have Northern Ireland within the United Kingdom, but again, you can see even from this survey how important it is, because everything overlaps, because we are, let us face it, in a global community now. Thank you to everybody concerned, especially to Margaret Brinig, who's brought everyone together, and to Intersentia for undertaking to publish this work. You make our lives a lot easier. It's useful to have this, certainly for people like me as practitioners, to get a feel for what is happening in this new decade. Thank you to all. Bye-bye.